is Ter Blanche doing? He had dental surgery. Is Honorable Ter Blanche?
So, Oban.
How is Honorable Ter Blanche doing? Whitfield?
Hi, good morning.
Is Honorable Ter Blanche here today?
Chairperson, it's Nicolette. We had an apology from Honorable Ter Blanche.
Yes, he has had dental.
Well.
Sorry, his operation went well.
Yes, I spoke with him yesterday and he is recovering well and he will be up and going soon.
Our prayers are with Honorable Ter Blanche. She's having quite serious dental surgery. So our prayers are with him. Honorable members, I'm ready to start. Nicolette, Babawa, do I have a quorum now? I'm still looking for Whitfield.
Morning, Chair. Yes, we do have a quorum.
Thanks, B. B, is Honorable Whitfield here? Is he going to be here today?
I didn't get any apology from him, Chair. Let me just quickly phone him and find out if he'll be attending the meeting.
Yes, I need all the political parties here today. Dr. Groenewald? We need all the political parties here today. I don't see Majosi. Has she apologized?
Morning, Chair. Unfortunately, I had some audio problems in this when we started, but I am here. Thank you. Good morning to everyone.
You. Morning, Dr. Groenewald. Onthou is 'n lang naweek, nee?
Ek het vergeet daarvan, ja.
Ja, asseblief toch 1 uur dan skop ek julle almal uit, nee.
Wel, as dit 'n lang naweek is, moet jy dit al 11 uur doen.
Dankie. Honorable colleagues, I need political parties here today. That's why I'm checking with all of you. I don't see Majosi and I don't see Whitfield. Ter Blanche is ill. So could you please indicate to me if Whitfield joins the meeting? In the meantime, do I have a mover for the adoption of the agenda? We are going to do...
Sheikh Imam.
Sheikh Imam moves for the adoption of the agenda. We did the apologies. Apologies, Babawa. The apologies, please.
Chair, I received the apology from the minister, from the deputy minister, from Honorable Molekwa, from Honorable Patrain. Mr. Whitfield is about to join the meeting, Chair.
Wonderful. So we can start. Mr. Whitfield, Honorable Whitfield would be joining us soon. That gives me the DA. And so I just do not have the IFP. Honorable members, I'll start then with the Civilian Secretariat. We've done the apologies. The opening remarks would be unnecessary. This is a continuation of last week, Wednesday's meeting. Dr. Lynch, thank you very much for joining us again. The members of the public who are here, thank you very much for joining us. General Vuma, your team. General Vuma, could you just indicate who we have from, are you leading the team, General Vuma?
Honorable Chairperson.
Good morning, Honorable Chairperson. The person who is leading the team is General Masemula. Thank you very much.
Thank you. Good morning, General Masemula. Are you ready with your team?
Morning, Honorable Chairperson and honorable members. An apology for the National Commissioner is busy with other security-related matters of handing over. And with the team, you had General Vuma is with us, Honorable Chairperson. I also have got Lieutenant
Recording
General,
in progress.
Lieutenant General Ujinga, the Deputy National Commissioner for Crime Detection. And yeah, and then I've got most of the divisional commissioners are also on. And yeah, no, thanks, Honorable Chairperson. All senior managers of SAPS, we have them on board. Thank you very much.
Thank you very much, General Masemola. General Mulaudzi, thank you very much. I saw General Rick here as well. General Masemola, are you introducing your presentation? I'm starting with the Civilian Secretariat, please. Is Dr. Jacobs doing your presentation? General Masemola, are you introducing?
Chairperson,
Are you introducing? Thanks, Acting Head. Will you introduce?
yes, the team, the whole team from legislation, Advocate Bell, Dr. Jacobs, and all other staff members are in the platform. Then Advocate Bell will take the lead. Thanks, Chairperson.
That is wonderful. Can we just again, so you are going to do your presentation. Members, do we do questions after their presentation, or do you want both presentations and then the questions?
Both, please, Chair.
Morning, Honorable Whitfield. Can we do both and then take questions?
Yes, please, Chair.
Agreed?
Yes, Chair.
Agreed. You may start, Civilian Secretariat, you may start.
Chair, I thought I must just let you know that I'm in.
Honorable Deputy Minister, thank you very much. I didn't see you here. DM,
Yeah,
you
no, I struggled with connectivity, but I'm connected. I think you can proceed, Chair, with the Secretariat. I just wanted to let you know that I managed to connect.
my apologies for not seeing or recognizing you, DM. Honorable DM, the committee will all be losing connectivity soon. You understand? The chair will exit the meeting and the meeting will be ended. So you must indicate to your team that it's long weekend and this committee will all lose connectivity very soon.
Okay, Chair. We'll make them away.
Thank you, DM. Civilian Secretariat, you may start and then I'll take the DNA board and then we'll do questions.
Dr. Jacobs will present. Dr. Jacobs.
Thank you very much, Chair. Chair, we are here to respond to the number of issues that were raised.
My apologies, Dr. Jacobs. My
which require a
apologies.
response from the Civilian Secretariat for
my
Police Service. We also, from our side, want to express our support for the contributions made by the presenters, which I think enrich the whole debate.
Dr. Jacobs.
So we will respond on the issues just here under.
Honorable Moss,
if we can
please
go to the
mute
next
your
slide,
mic. I'm
please.
sorry, I'm speaking while Dr. Jacobs is speaking. Honorable Moss, could you please mute your mic?
May I now? Yes, Chairperson.
Mute your mic, please. You may continue, Dr. Jacobs.
Thank you very much, Chair. Chair, I just want to say again that there's a number of issues that we need to respond on, and we also appreciate the inputs that were made in the different contributions which enrich the debate. So we will respond on the various issues here under. If we can go to the next slide, please, Solusani. Chair, firstly, the issue about the proposals in respect of Schedule 8. And it was proposed that it should be obligatory to take DNA samples from every person subsequent to being arrested, irrespective of the crime allegedly having been committed. Chair, firstly, I need to say that the bill before us is about convicted offenders and not really about the whole bill. Schedule 8 and the sections dealing with the taking of DNA samples otherwise are being dealt with in the Criminal Procedure Act, which is not really before the committee at the moment. But I think we do have sufficient replies as well in respect of those issues. What's not on the slide, and that's what I'm going to mention now, is that if you would look at section 36 D2, you will see that the police have the power to take a DNA or any other sample of any person after having been arrested or summoned, etc. In other words, there's already provision in the Act that the police can take a DNA sample in respect of any offense. It is just that it's not obligatory, but of course the value of DNA in that specific investigation or to prove the matter will give an indication on whether DNA must be taken. But I think the provision is much wider than have been perceived during our previous discussions. When the Act was drafted initially, the Schedule 8 offences have been selected from the serious offences in the schedule to the Criminal Procedure Act on the basis of exactly the relevance and value that DNA sampling have in the solving and proving of those cases. And we see that there's a huge overlap of these offences in the set schedules. Schedule 3 just deals with mostly with traffic offences. Chair, one of the items in Schedule 8 of the Criminal Procedure Act includes any conspiracy, incitement, or attempt to commit any offence referred to in the schedule. And you will recall that it was said that attempted murder is not included in Schedule 8, but in fact, as a result of this omnibus clause at the end of Schedule 8, all attempts to commit an offence in terms of Schedule 8 are included. Sexual assault against any person or sexual offences against children and mentally disabled persons are already included in Schedule 8. And the taking of DNA samples is applicable to persons in respect of Schedule 8 offences after arrest, but before appearance in court, when released on bail and upon summons. Chair, and that is applicable both to Section 36D1 and Section 36D2. If we also look at Section 36D1B5 of the Criminal Procedure Act, we see that buccal samples may be taken from any person charged or convicted by a court in respect of any offence which the Minister has by notice in the Gazette and after notification of Parliament declared to be an offence for the purposes of this subsection. So indeed, in the present Act, in the Criminal Procedure Act, there's provision both in Section 36D1 and 36D2 that Schedule 8 can indirectly be expanded without any amendment to the Act. Can we go to the next slide, please? Concerns have been expressed about the ability of the SAPS to be able to comply with the obligatory taking of DNA samples of convicted Schedule 8 offenders, as well as the existing backlogs. And in addition, if DNA samples must be taken of every person being arrested, irrespective of the charge and for minor offences, the cost of implementing the Act would become enormous without any benefit of solving or proving a huge number of crime where DNA is not relevant to the solving of the crime. And as I've said, where it is relevant, it can in any event be taken irrespective of the offence. It will also place an unnecessary administrative burden on the police officials as well as the Forensic Science Laboratory to take a DNA sample of exactly every offence for which a person is being arrested. So the recommendation is that the taking of DNA samples should remain restricted to Schedule 8 offences as they are presently, with the possibility of adding the offences by the Minister of Justice and Constitutional Development by notice in the Gazette after informing Parliament. Chair, the issue about the Audi Ultram Partem was heard, and it was said that this rule, and that is the rule to hear the other side before decision is being made, before a warrant is obtained for the taking by the use of minimum force of a buccal sample of a convicted offender. Chair, it is not practiced nor legally required to apply the audi alteram partem rule in respect of the obtaining of a warrant. It is presently provided in Section 36E, for example, of the Criminal Procedure Act, that the buccal sample may be taken of a person or a group of persons if there are reasonable grounds to suspect that the person or that one or more of the persons in the group has committed an offence referred to in Schedule 8. Also, when it's reasonably believed that the buccal sample or the results of the forensic DNA analysis will be of value in the investigation by excluding or including one or more of those persons as possible perpetrators of the offence. And when a person can voluntarily undergo that DNA test or sampling, but when the person refuses to undergo the sampling, the Act provides in Section 36E that a warrant may be applied for without applying the audi alteram partem rule. So it's not a requirement in terms of that section. Chair, the proposal was made that the capacity of the forensic science laboratory can be expanded by cooperating with university laboratories and other capacity in the private sector. This can certainly be explored, but we must bear in mind that the integrity of the chain of evidence and being able to prove disputes in court about the analysis of the samples and the capturing thereof on the National Forensic DNA Database needs to be adequately addressed. But we do not support that the bill be held in abeyance as was suggested, pending proof of ability of the SAPs.
Recording stopped.
Chair, as was stated on your agenda, the delegation SAPs, I'm sure the committee is going to explore that issue further today. Chair, the issue of minimum force. As it was rightly stated, minimum force may be used in basically every jurisdiction to ensure that fingerprints or other samples may be taken for purposes of enforcing and applying the law. It was also repeatedly stated there's already provision in the South African Police Service Act
Recording
in
in
Section
progress.
33B that where a member of the police service is authorized by law to use force, he or she may only use the minimum force which is reasonable in the circumstances. The bill also provides in the proposed Section 77C for national instructions that may be issued by the National Commissioner regarding the use of minimum force. Chair, and then it was noted by the Judicial Inspectorate for Correctional Services, Judge Edwin Cameron, and we fully support that note that the bill allows minimum force to be used, and this is linked to use of force as envisaged also in Section 32 of the Correctional Services Act, and expressly mentions Section 32(6), which provides that all instances of use of force in respect of convicted offenders must be reported to the Judicial Inspectorate for Correctional Services. Chair, then once again about the capacity of the SAPs, we believe it will be addressed in the submissions after us. We can just mention that when we put into operation from the 31st of January, Section 36D1 of the Criminal Procedure Act, namely the obligatory taking of DNA sample of Schedule 8 offenders, we first confirmed with the South African Police Service that they will be able to implement that section fully from the 31st of January 2022. Chair, thank you very much. I hope I've responded to all the questions, and if there's anything else, we can follow it up. Thank you.
Good morning again, General Reid. Good morning again, Dr. Jacobs. Thank you very much for that detailed presentation. All the members have taken notes, and they will use those notes when I take the opportunity to allow them for questions. Dr. Jacobs, you can now mute your mic, please. Dr. Jacobs, please mute your mic so that I can take the next presentation. Thank you very much. Then, DM, are you introducing the board?
The chair of the board and is not able to join us, chair, because of a court case that she's attending to. But we have requested that they should send the secretariat of the board to be in the session. I hope they have done that. Acting chair, I hope the secretariat is part of the meeting to present on behalf of the board. Thank you, chair. Through you, if you may allow.
Thank you, DM. DM, who's going to introduce the members of the board who are here?
Tagalani, can you assist?
Yes, DM. Good morning, DM. Once more, good morning, Chairperson and honorable members. We have the Deputy Chairperson of the board, Mr. Raymond Zondo, who is going to do the presentation. I need to indicate that maybe because of the short notice, most of the board members couldn't attend today. But Mr. Zondo is here to assist or to lead the presentation. Through you, Chairperson, I will ask Mr. Zondo to take over.
Thank you very much, Takalani. You may continue with your presentation. Where's your presentation? I'm still seeing the one of the Civilian Secretariat. Now it's the DNA board presentation. You can start. DNA board.
Thank you, Chair. Thank you, Secretary DJ. Thanks to all members of honorable members of the House. I am Raymond Sono, Deputy Chairperson of the board.
Sorry,
thanks for the opportunity to come and present.
My apologies, Mr. Sono. Yes, you are audible, but can you just show us your face so that all the members, they interviewed you, but they'd like to see your face again just to refresh their memories. We'd like to see your face. All right. Honorable members, that's Mr. Sono. He'll be doing his presentation. We all just needed to see you. You don't need to keep your camera on. If you'd like to, you can keep it on, or else you can continue with the presentation. Thanks.
Thank you, Chair. For the sake of networks, let me just use my audio.
Oh, thanks a lot.
Without the camera.
Okay.
Okay, thanks a lot. Chair, let me just go straight to our presentation. I would like to indicate that the board, since the inception of the board, the diagnosis of challenges that faced the FSL led to the board through the permission of the minister to take more meetings with the divisional commissioner and the general with his DFS, more than we were expected, because we're supposed to have only 4 meetings annually, but this was pending what we are, or was with regard to our presentation. We are aware that our presentation should be, or our capacity of FSL observation was supposed to be divided into 2. Our meetings, reports that we receive from the FSL, as well as our visitation and observations to the lab, with which the standing subcommittee of technical led by Dr. Ehlers is responsible with this regard. But let's go straight to the papers, then the answers to many questions will be answered as we go through. We aim to provide the portfolio committee on police with 3 principal aims: to performance status of the FSL as at the end of Q3, functionality of the National Forensic DNA database, and observations of the capacity of the FSL to effectively process DNA sample. Obviously, when we check the above, we will understand that the national database is the main indicator. Hence, once we receive its product, we know what is happening in the process. Let us go to the next slide, please. Next slide, thank you. DNA analysis performance overview. Since this helps a lot to determine the capacity. The starting point for assessing the performance of the Forensic Science Laboratory, the FSL, is analyzing the case finalization rate against predetermined benchmarks across various case categories. This simply means that we are safeguarding in our monitoring cases that are supposed, the benchmark we refer to cases that are supposed to be, flags of cases that are supposed to be analyzed on daily basis, which are supposed to, it's just a normal work, versus cases that are supposed to be extra. For an example, the backlogs. So which should be ring-fenced. Already we are familiar with that. Essentially, this presentation report will consider the actual volume of cases being handled in order to gain an accurate reflection of the performance of the laboratory. An important indicator used in that is the case backlog and at hand at the time of reporting. This might be the reason that our diagnostics of problems with the FSL were in the inception of the board. We realized that we have got stagnancy of the lab. The lab was not operational. And maybe to take it a little bit further, Chairperson, with the help of the PCOP, Minister, DM, we are very happy as a lab, as a board, because out of the meeting on the 17th of February, that included the Treasury, CETA, and so I think you remember the meeting. It was clear to all of us that the principal challenge in the FSL was the contract management led by or emanating from the SCOPA DFA saga that led to the CJS budget in the FSL to be in a deficit, I think, of 250 million, with which, out of your leadership, we happen to have a baseline budget of 250, where we saw, thereafter we saw contracts which we are, as a board, monitoring that are now in place. If I'm not mistaken, all of them up to now, they are now up running or awarded. Can we go to the next slide? Next slide, please. Oh, can we go, which one is the next? Let me see. I think it's backlog reduction. Can we go to backlog reduction? Thank you. A special project on ring-fenced backlog. Now we are coming to one of the special indicators of whether the processes of the FSL are working and whether they are capacitated or not. The ring-fenced, bullet number one, the ring-fenced backlog at the beginning of June 2021 was 210,864. I think the meeting we had in the police college with the PCOP, DFS, gives this reflection. If you still have that presentation by the division, this information can be deducted from there as well, which was 15 May. So in June, we still stood at this 210,864. On 31st December 2021, this number had been reduced to 72,306. And that is what we observed on our meeting with the DFS physically in the Lieutenant General's Board in the FSL in 26 November last year. Effectively, the ring-fenced backlog has been reduced by over 65%. And this had to do nothing else to us as a board rather than to be excited about this production. Can we go to the next slide, please? Thank you. The national forensics, functionality of NFDD, loaded vessel expunged. The National Forensic DNA Database. The number of profiles loaded onto the various indices of the NFDD is important indicator of the effectiveness and efficiency of the database. As I said before, you will never have, the NFDD is the end product of the electronic sample, which had been started from exhibit level. So once you get any profile loaded, it means all processes of analysis are functioning. In particular, the goal is to ensure higher loading rate on the convicted offender, arrestee, and crime scene indices. This is with regard to relevance to this meeting, because we now are in a bill issue. So when we talk here of the arrestee index focus, we are getting more advantage in terms of functionality and capacity of the lab, because we are looking only at arrestee and we are looking at only swabs. So one swab equals to one case. There's no complexity. So it means it's a routine work, which is supposed to be very easy for the lab. So now the period and the loaded profiles and the expunged profiles, in Q1, we still had a lot of problems due to number of contracts that were not yet awarded. Some in process, they were busy still. The logistics or supply chain section was still having challenges, but we applaud them because they worked as well at a speed of light. So now, in Q1, 2021-2022, 8,972 were loaded, and then in expunged profiles 17,334. We're still in a disappointing era. Q2, 2021-2022, we have got 19,138 cases loaded or samples loaded, with which it was against 1,292. And this put a smile on our face as a board. And we went to Q3, which is the quarter before this quarter, 57,657 cases or samples. As I said, in terms of indices here, in terms of arrestees, we are talking about one swab being a case on its own because it comes with no crime samples. So there is no CI lane run in this regard. So we are talking of 57,000 cases loaded against 22,857 cases expunged. We are not happy about the number of cases expunged, yet we are very happy about the number of cases loaded. And this, I think, is another aspect to discuss in terms of this huge number of cases that are expunged. We are in a pipeline of trying to recommend as to how are we going to add more of the amendments that will keep profiles until we are satisfied these profiles were not of contributors nor perpetrators of crime. A comparison of data analysis presented for the 2 quarters as depicted above table shows a significant escalation in the number of forensic profiles loaded onto the database with a lower expungement rate, which is quite encouraging, basically because it tells us about the functionality of the lab in all processes, since they are interdependent to one another. It is therefore adorable that we have number of cases that we are seeing as an end product of efforts that the FSL is putting there. So I think here we can go now to the next slide. Other indices, which doesn't concern much, though are interlinked to all indexes of the database or indices of the database. For instance, the convicted offenders index is directly proportional to the arrestees index. We have got a high number of the arrestees index because this is supposed to be samples coming from all arrested persons, innocent or not, proven guilty. And when you check the 368 number of convicted offenders there, you will forgive us for the comments below. It seems to be very, very, very low. It is the indexes that are deducted from arrestees index after one had been found guilty, because the convicted offender is found guilty, but the arrestees, all of them are not found guilty. So it's not necessary that a convicted offender, they went to him to take samples. Obviously, it's not necessary. If you are convicted, you are found guilty, DNA profile or not. So elimination index 655 loaded, nothing expunged. These are the profiles of people working with DNA samples. So then their mixture profiles in the sample, crime samples, will be excluded, seeing that investigation were made that they worked with those samples somewhere, somehow. So the crime scene index, CI lane, is a different lane from a reference index, which is RI, with swaps that now we're focusing on in the bill. We are dealing only with RI index, which is the reference index. So reference samples index. So now it's 8,192. It's okay, nothing expunged. Missing persons that we hope to find their families. We hope the codice shall be in a time that doesn't delay be signed in for familial searches. We've got missing persons unidentified 543 and nothing expunged. Investigative index 2,328 and 182 expunged. 2328 loaded. Arrestees index very high, 45560 against expunged 22675. 22675. The total number of all these indexes, 57657 loaded in the database and 22,857 expunged. Still, it's a good news on our side. Though we say we are dealing with the issues of retaining profiles and for a period of time that will be satisfied that there could be no either serial chance of linking serial perpetration of crime by those whom in a particular case they were not found to be linked to any case because through experience criminals have got a tendency to repeat crimes. So even if they are not found guilty in most cases, they are still found to be guilty in other cases. So that is the prevalence of general thinking. it is quite noticeable that figures in the convicted offender index are extremely low. This may be attributed to, please replace 1 and 2 and forgive us with the reasons I gave, that lower because they are deducted from arrestees index that were found guilty. So we cannot say it's compulsory that all of them may be found guilty at the same time. Those that are left in the database may be found guilty in other times or innocent. So let us go to the next slide, please. Taking of buccal samples for prioritize the Schedule 8 offenses. Maybe this may also answer the question of, do we have challenges with this regard? If we have challenges, is it the capacity of the lab, or is it other factors that we may find? It's up to us to find out. The ability of detectives to collect buccal samples is critical to the success of the NFDD, and ultimately the police goal of optimal utilizing forensic in criminal investigation. One of the key stumbling blocks to achieving this has been the low compliance rate by detectives nationally in taking buccal samples from arrested Schedule 8 offense. So there is factor number one we can note down. As per the below table, the comparison of the three quarters indices, that compliance has been consistently high for the past 2 quarters, denoting an improvement from a rate of 46% at the end of the previous financial year to 79% at the end of Q3. So now we can see, it seems as the earlier or the closer the date of introducing the action of taking swabs towards probably the education given or whatsoever factor positively improves the compliance, possibly by both the collectors and the people that the swabs are supposed to be collected from. However, a deeper analysis shows that in most provinces, with the exception of Gauteng, KwaZulu-Natal, Eastern Cape, and Western Cape, these compliance rates were achieved of low base number of suspects arrested for Schedule 8 offense. It can be suggested that the number of the provinces not mentioned above two are very low, and that signifies improvement can be made. We are not having evidence as to why these provinces where the labs, the decentralized labs are, people complied. Maybe it's the knowledge of the DNA and its use. In other provinces, we realized that compliance wasn't that. Can we go to the next slide, please? My computer, I have lost my own slide. Okay, let me try to search. I'm sorry, I'm busy. My computer has lost my table. I don't know how. Okay, I got it. Thank you. Let us check, maybe to sum up, even if we don't read numbers, but let us check the continuation here, the table. Look at the province at your far left, I'm sorry. And at your far right, we have got the Q1 of the previous financial year, where we had lesser compliance. From Western Cape, we learned that we had 27% compliance rate in Q1. And as we come closer to where we are today, in Q2, then we have got 64%, Q3, 66%. And this simply means that out of 28,608 number of suspects arrested and charged for Schedule 8 offenses, we only had 19 cases, 19,129 cases of those that complied. And then let us use it as we check now, maybe the total of all provinces, even if we don't check each province, is the same linear graph to all provinces. We had this 46% in the totality, which is the bottom row. We have got in the far right column 46%. As we come to Q2, 77, Q3, 79, and we managed to collect 114,464 buccal swabs against the total number of those that were arrested, 145,422. So you can tell others wouldn't like their swabs to be collected. And what may be the reason? They might be taking an advantage of the bill not yet passed or whatsoever, yet they are afraid of something that is a showcase, or it's a total knowledge of what DNA can do. Because some of the people may think that even other trespasses that is not even related to DNA analysis may be picked up from their side if this DNA is collected from them. May we go to the next slide, please? General observations. Now we come to the work which the PCOP would like us to supply them with the work. Based on general observation and engagements with the FSL management, a conclusion can be drawn that the capacity of the laboratories is in positive state to be able to deal with implementation of the DNA bill amendments. Why? We are now standing presently at a situation where the 4 RI lanes or reference index lanes that are available are well equipped to process a large number of samples on a daily basis. Presently, according to information from the SAPS, 3 of these are in Cape Town, as we saw from other previous presentations by the divisional, by the division DFS. Western Cape seems to be larger than the head office, Pretoria, in terms of capacity and human capital. So, according to information, we deduct that from SAPS, 3 of these are in Cape Town, and with 29 members that are revolving around the system for loading, I mean for the use, for the utility, and 1 lane in Pretoria, and 15 members are working on in this lane. The current monthly influx, which is of more interest, of samples being processed, stand at 21,008, and out of this 21,000, which is now the benchmark we spoke about before, 8,000 from Pretoria and 13,000 from Cape Town. Why are we talking about only these 2 labs and rather not talk about Eastern Cape and KZN? Is because when we talk of RI lane is applicable post-extractions, meaning that we are talking about when an exhibit is converted into sample and a sample now is converted into a sample now is converted into a we call it the liquids that you can run into the lanes. So you are closer to electronic sample now. So Eastern Cape and KZN is what we are fighting for, that they must be fully fledged. The day they are fully fledged, you will hear that the RI lanes are running in KZN and Eastern Cape, and that is in a pipeline. We, in a very short space of time from now, will be hearing the message I'm talking about. We are optimistic as a board about that. As we work closely, hand in hand with the division, we are quite sure, we are saying it without doubt and without being embarrassed. So can we go to the next slide? The RI lane have the capacity to process about 57,000 samples on monthly basis. So you can work it against
Mr. Sono, am I the only one that's lost you? Members? Have we lost Takalani?
Yes.
The same here.
Yes,
Takalani, we lost you?
No, I'm still here, but I will check
Yes.
him.
Your presentation is lost. You're in charge of this presentation and I've lost him.
Okay. Maybe if I can
Can you continue or must we wait?
No, I will continue.
Thanks, Takalani.
So in terms of the
Sorry, Chair. I had a problem on my side with the network. I think I'm back.
Okay, you may
Sorry,
continue.
Chair, and the House. I was saying the RI lane have capacity to process about 57,000 samples on monthly basis, which implies that the current capacity is sufficient to handle the influx of samples and with the extras of 36,000, which can be focused on. Am I audible?
Yes, you are.
Oh, thank you very much, Chair. I was saying the RI lane have got the capacity in the present of 57,000 samples on monthly basis. Meanwhile, we are receiving the influx of, is it 21,000? So we are remaining with the additives or the space capacity of backlogs and other stuff or extras of 36,000. And that also gives us a good news. The main challenge currently is backlog, which means once the backlog is finished, which is anticipated to be done with around August this year, the labs will be able to cope well with the demands. Human capacity at the lab is also adequate and well-trained to operate the systems. The challenge may be at the actual collection point at police stations level, which is something that the SAPs will need to pay attention to. Next slide, please. In conclusion, the board's phase approach to monitoring and overseeing the progress made by the DFS in respect of identified key priorities area, the backlog reduction, contract management challenges seems to have yielded a noteworthy of positive results. Low compliance rate by detectives in taking baggage samples from suspects arrested and charged for Schedule 8 offenses continues to impact negatively on the performance of the NFDD. The board has also established that the main challenge at the FSL has been poor contract management, which led to the huge backlog, and the capacity has not really been a challenge. With this, we try to indicate that we may think we have all we need in the lab to operate, but since the lab is broken into or is segmented into sub-labs, if you have one of the sub-lab, the interdependent depend to one another. If you have one sub-lab, which may have a challenge with even a small consumable or reagent, you will have to have the whole process stop. You will have nothing in the DNA database that will be loaded. You need all of this to be in place and to be up running smooth. You need one after the other. They depend on one another. The board is in the process of building corporate governance systems to enhance its capacity to perform the required duties effectively. Now we're talking about ourselves because it depends on whether the board is also aligned well to be able to monitor and help with oversight work. So after finding that the lab was stagnant when in the inception of the board was not operational at all. Therefore, it came to our attention that we must treat the issue of kickstarting the lab with emergency. As we never even focused on ourselves in terms of building our standing subcommittees, we were in fact reacting to the challenges and focus in the issue of backlog and the uprunning of the lab. Hence, presently, we have a leverage to build up ourselves as per our individual expertise in the board. We are busy sharing the responsibilities, but we are keeping ourselves at guard and monitoring of the lab. And once our corporate governance is built, it means now we will not be proacting to any problems. We will be putting efforts to reach the objectives and the goals that will be set and be clear to the PICOP, to the minister, and to the deputy minister. So before our tenure comes to an end, we will have to achieve it, or else the next board will have to carry on and achieve. Let us go to the next slide. Recommendations as we come to an end. The subcommittee led by Dr. Ehlers will continue to oversee the DFS turnaround strategy through the approved POA. This subcommittee is the technical subcommittee, which was responsible to develop the POA, as was given or is given a directive by the minister. The board will develop a schedule to visit the FSL in order to verify their capacity and be able to make a conclusive determination on the sufficiency of the systems in place. So now, I have to clarify that the board didn't decide to visit the labs because of the call to come and report today. The board thought of visiting the labs, I think, immediately after inauguration, as the way of diagnosing the lab, because we wanted to avoid to do work when it's very early, it's late. So now, evidence to this is on the 26th of November last year, we arranged with a division that we are going to do our first visit here in the head office. Unfortunately, they had a COVID case, which we were not all allowed to enter the lab because of fumigations. But we were there, we had a meeting with them, which was aimed to attend to that. We are sorry. I was off again. I'm back. Can I continue, Chair?
Yes, you may.
I'm sorry for that. Chair and the House, the intentions I was saying, the issue of making visits to the lab had been in our minds since the inauguration day by the minister, because it was part of diagnosing the lab. We were afraid that we will be late if we don't start by doing so. So now it has been planned that the intention is to have the first visit again before the end of this financial year, meaning this is the last quarter of this around 31st March 2022, and have one visit in the next financial year in each quarter, the 3 consecutive quarters, we are going to visit each and every lab. When we visit there, we are going to start from case reception, ER labs, extractions, electrophoresis, up to the end. We were also going to make sure that we see the NFDD with Bricksmith as well. And we are going to check the functionality of machines, interview few workers, and find out if there are problems, which obviously we shall recommend to the general as to what is required to improve services, as well as to report back to the PCOP about our findings. For now, we are honestly working on the reports that we are getting from the meetings and their submissions as a division. And we are now at the level of loyalty and trust to one another, that whatever we receive is a true reflection of what the lab is. So now we will come back as soon as possible to report about our personal findings in our physical visit. The full capacitation of the EC and the KZN laboratories. We are also in support and on top of this recommendation that the Eastern Cape and KZN laboratories must be fully fledged, meaning that when we talk of RI lanes, they must be running in there as well. But in a current situation, we are satisfied that we are up running. So depending on national crime prevalence, as the crime stat is delivered nationally, we are at watch as a board that the most prevalent province, when we look at the other provinces that do not have decentralized labs, will be the next lab to be recommended for the laboratory. However, we as a board recommend that there should be an establishment of evidence recovery in all sublab in all provinces that do not have labs, seeing that it is very much costly to transport exhibits from provinces to Pretoria. But if we can reduce exhibits into samples, even a small private car can carry thousands of those samples and transport them for further extractions and other stuff in the fully fledged laboratories, with the aim that in a long term plan, all our provinces must have fully fledged laboratories, which is to protect against our population growth in South Africa and this potential crime that we all are crying about. I thank you for an opportunity to present. Thank you.
Thank you very much, Mr. Sono, for that very detailed presentation. You can accept the concern of the committee and the frustration of the committee around the forensic science laboratories. I'm not going to express that frustration. I'll leave it to the members to speak for themselves and on behalf of their political parties. Honorable DM, you may say your closing remarks, give your closing remarks, and then I'll take questions from the members. Honorable DM.
No, it's okay, Chair. I'm happy with the presentation. I think let's allow members to raise questions. Thanks.
Thanks, honorable members. You may raise your hands now.
Honorable Chair, Honorable Chairperson.
No problem, General Masimola.
Thanks. There is a presentation by General Ravi on responses by members of the public. I don't know whether we can take it once or after the questions.
General Ravi, Why don't you do your presentation now before I take questions? General Rabi, are you happy? General Masemola, would you be happy if I do your presentation now?
Correct, Honorable Chair. I think it will be better that way. Thanks, Honorable Chair. General Rafi, can proceed.
My apologies, members. I didn't know about this presentation. It may have slipped me. General Rabi, you may proceed.
Good morning, Honourable Chair and honourable members of the committee, our Honourable Deputy Minister and the senior management of the South African Police Service, the CSPS and the chairperson or deputy chairperson of the DNA board. Ma'am, yes, I am ready. I can start with the presentation. The presentation itself, Honourable Chairperson, is informed by the inputs from various interested parties on the proposed bill, and we have structured our presentation according to that. As far as the background is concerned, just briefly, we have received a request from yourself, the chairperson of PCOP, to respond to the matters that has been raised in the public submissions on the bill, and those have now been included in the presentation. Honourable Chair, as far as our presentation is concerned, while the presentations were made by Dr. Jacobs and Mr. Sono, I correlated the information that we have, and there is quality correlation between the presentation in terms of the statistics that we are quoting, as well as the reference to the relevant legislation. Just as in part of the introduction, Honourable Chair, in terms of the types of evidence requests that are being received at the Forensic Science Laboratory, there are two categories. These referred to as the crime samples. That includes your more complicated samples and takes longer to process. And these analysis, DNA analysis, is performed on the manual and the crime index semi-automated lanes. As indicated, these type of samples are more intensive and time-consuming to analyze. The second category is the buccal samples, and this is being processed on the reference index semi-automated lanes, and this is what we will focus on for the purpose of this presentation. And the bill, with specific reference to the bill, it aims to authorize the taking of buccal samples from offenders convicted in terms of offences referred to in Schedule 8 of the Criminal Procedures Act. Now, Honourable Chair, when we look at the commitments by the Forensic Science Laboratory, the processing of collected buccal samples is obviously being prioritised, and this will also aid the efficiency of the National Forensic DNA Database, as Mr. Sono referred to. And the purpose of that is to generate potential leads to resolve cold cases and to identify serial repeated offenders by loading all forensic results generated from the reference index system. What has been done to achieve this?
My apologies, General Rabi. We will receive a copy of this presentation, so please do not read everything. We'll be losing, all of you will be kicked out quite soon, and you don't want to be responsible for ending my meeting prematurely. General Rabi.
Noted, Chair.
You will not be invited back to this meeting if it's too long.
Noted, Chair.
Thank you.
Chair, the long-term contracts has been put in place to support the processes within the FSL. There's also the operational plan, and the way that we deal with forensic exhibits has been purified to make sure that the backlog is addressed, and at the same time we process the new exhibits that are being received. And the analysts that we have trained in that capacity, all the people that are responsible for that have been properly trained, and we will also allocate an additional 34 hours of overtime to the specific analysts. Just briefly, Honourable Chair, when we look at the backlog, and as I said, this is only as far as reference samples are concerned, this correlates with what has been presented by Mr. Sono. The current backlog where we are standing is, that includes a backlog of 67,434. And the ones that are currently within the 35 days, we are standing at 56,000, a total of 123,509. Just a note on that, Chair, the backlog on the 7th of February was at 110,913, and that has now been down managed to 67,000. The capacity has been dealt with by Mr. Sono, and the detail is on the slide as you indicated, Chair. I just want to highlight, as far as our reserve capacity, the bottom of the slide is concerned, Mr. Sono also referred to a reserve capacity of 36,600. That means that is what we will be able to process in addition to the monthly influx. But what we'd just like to note there is that we need to apply a contingency allowance of approximately 20% to cater for downtime for maintenance of the planned and unplanned maintenance, as well as potential network problems. That brings it down to a reserve capacity of approximately 30,000 per month. The costing of the Act, Honourable Chair, it is estimated that the total implementation cost will be approximately 78.5 million. Now, the direct cost, all of this associated with the Implementation Act has mostly been included in the model, the costing model itself. And both national and provincial competencies perform these activities associated with that, and we are confident that the funding is appropriate to meet the demand. On average, we spend approximately 200 million on consumables that relates directly to the forensic processes. The implementation of the Act, since inception, just shortly, we have prioritized the taking of buccal samples. Although the reference was made to Schedule 8, we encourage our detectives to prioritize the taking of reference samples. So as a result of that, we did not take routine buccal samples from all persons has been arrested in terms of Schedule 8 offences. Now, although this is a negative outcome, it also provided us with the opportunity to prepare for further implementation of the Act in terms of getting our contracts in place to make sure that we, for example, distribute the necessary buccal samples, and at the same time making sure that our laboratories have got adequate resources to process and support DNA analysis. As far as the further implementation of the Act is concerned, Chair, it is important that we, in terms of the IJS project, we allow for that specific project to look at the integration of the system from correctional services and the South African Police Service to we have not fully populated, as Mr. Sono indicated, the National Forensic DNA database. We have, however, taken just over 1 million buccal samples from persons that has been arrested in charge. And in order to deal with the outstanding number of buccal samples, a project will be initiated between the South African Police Service and Correctional Services to determine what is the percentage of buccal samples that still, or the number that still needs to be taken. When we look at the issue, Honourable Chair, of consequence management, as Mr. Song also referred to, we have not achieved certain of our targets that relates to the processing of DNA. In the first months of 2020, there was a problem with the availability of the DNA kits that has since been addressed. We also had the COVID-19 pandemic that impacted on our ability to deal and collect the samples. For instance, there was hesitancy or reluctance from members to take these samples given the COVID-19 potential infections and the consequences associated with that. We have, however, Chair, improved, and as also indicated by Mr. Sono, we are currently standing at the end of Q3 at a 78.71% compliance as far as the taking of buccal samples is concerned. As far as the establishment of a DNA population database is concerned, it is considered unconstitutional and also not aligned to international practice. This view is supported by the National Forensic Oversight and Ethical Board as well as the SAPS Legal Services. It is proposed, Chair, when such a national population DNA databases be established, that it be hosted and will fall within the domain of the Department of Home Affairs, and that SAP should then be allowed to use this database as similar to what we do with fingerprints, to do comparisons between searches on the database that they will then be maintained by Home Affairs. We do not have a capacity within the South African Police Service to develop and maintain a full DNA population database. The buccal samples, as indicated, also we have taken buccal samples on the chair from 100,342 inmates at the relevant detection facilities. We are unable to, at this point in time, to indicate how many still or how many convicted persons have been released since 2017, of which the DNA samples were not taken, because this data is within the domain of correctional services. The service is also unable to indicate the number of people that are currently serving sentences that relate to Schedule 8 offences that we still have to take buccal samples. But as indicated in the previous slide, our proposal and our efforts is then to establish projects in the different provinces to facilitate the taking of buccal samples. The training capacity, Chair, yes, we have indicated our capacity to investigate crime at the various levels. We have capacity, but it's not sufficient, obviously not sufficient. We have been impacted on by the baseline reductions in terms of the budget allocation, and our establishment has dropped from at the top 199,000 to 178,000. But as reflected on the slide, we have capacity, people are being trained. Basic training, crime investigative practices, 13,000 people have been trained. Resolving of crime skills program, 16,000 have been trained. They're not going into the detail, just to illustrate that we have capability and that they are being trained. We've also phased out the detective learning program, and we have replaced it with the resolving of crime skills program. And we are currently on that program. We have 475 investigators that are being trained that will complete their training next week. And this learning program is then constantly developed. As far as the invasive nature of buccal samples is concerned, just to comment on that, in terms of the options that we have available, Honourable Chair, the buccal samples is the least invasive option that is available. I believe and assume that we understand how buccal samples are taken. We have two options available. First is that the person voluntarily submits to taking the sample and take the sample himself. Or the second option is that it's taken by an authorized person that will take the sample in terms of the prescripts and the training by the Department of Health. Both of these will not require the use of any force. The constitutional considerations, the legislation requires that our blood samples must be taken by medical practitioners. In contrast, as indicated, blood samples are a lot less invasive, but it also offers at the same time evidence with high evidentiary value. It's not only to ensure or secure the conviction of the person, but also exonerate the innocent persons. The use of minimum force, Honourable Chair, Dr. Jacobs touched on that, and I will just make reference to the fact that legislation makes provision for the use of minimum force, but it's important that it must be used in terms of achieving the desired objective and using the absolute minimum force that is required. And it is also then important that the proper risk assessment be done before we apply minimum force. This slide, Honourable Chair, I can skip. This talks again to the use of minimum force, which I think was also touched on, so I'm not going to go into that details. As far as the principles to consider in the proposed national instruction, Dr. de Kock also made reference to that. It is our view that what we need to include is the fact that the offender must be informed of the process that's going to be followed and explained. He must be afforded an opportunity to do it himself, and then if the offender refuses, then we will file an application for a warrant. And then if a warrant is obtained, we will then take the buccal sample with reasonable, necessary, and proportional force. We also at the same time keeping record of all incidents. Honourable Chair, the national instruction can only be finalised once the bill has been adopted by Parliament, because the content of the bill needs to be taken into consideration. At the same time, we will then consult with the Department of Correctional Services, and that will be completed once the parliamentary process has been finalised. Honourable Chair, thank you. That concludes our presentation on the comments that we have received. Thank you, ma'am.
Thank you very much, honourable members. Honourable Majosi is having network problems. Honourable Whitfield is also having network problems. I've asked them to send their questions to us or to me via WhatsApp, and then we'll return with a written response to them. Do you find that in order? General Rabi?
Noted, ma'am.
So I'll read their questions and their comments, and then you could respond to them in writing. Honorable members, you have an opportunity for questions now. General Masimola, your hand is still up.
Thanks, Honorable Chairperson. If General Mchinga can just make some closing remarks on the presentation with your permission, please. Thank you.
Thank you very much, General Mchinga.
Thank you so much, Chair and honorable members, DM and all subs management. My closing remarks is that we appreciate the presentations that were made, and also we align ourselves with those. Positive note is that we are seeing a very positive improvement in the FSL. We are continuously decreasing on the backlogs, and also on the issue of the buccal samples. We are moving very well, and also positive side of it is that all critical vacant posts were filled, and also the component head, the General Mulawuzi, is there actively involved, and his hands are on deck, and we have seen a change, and also with the members which are the morale is very high now. It shows that we are heading in a very positive direction. As we set ourselves the target of August, we are on par, and we show that we are going to achieve our goals by August. The backlog will be gone. Thank you so much, Chair.
Thank you very much for that, General. Honorable Shembeni, and then I also noted Honorable Marekwa. Is your hand back on? Honorable Marekwa, as yes, your hand is back. And then Honorable Groenewald in that order. Shembeni, Marekwa, Groenewald. Honorable Shembeni, the floor is yours.
I'm struggling a little bit, Chair. I don't know whether you can hear me that side. Am I audible?
We can hear you. Yes, we can hear you.
But you can't see me, isn't it?
No, we can see you, but if your network is bad,
he likes to be seen, Honorable Shembeni, Chair.
Aye, Shembeni loves. He loves. No, you are welcome. Honorable Shembeni, you're very handsome.
Chairperson, thank you very much. I just need some clarity here. According to the criminal law, this section 36D16V, that it allows now buccal samples to be taken from any arrested person, irrespective of a charge. And then now we are struggling to say there are people who are refusing to be taken buccal samples and so on. Like when we say the absence of enforceable law or provision compelling convicted offenders to submit to a sample being taken. I don't understand it there. That's why I need some clarity. The law that states that it must be taken from any person. That's section 36 of the criminal law. Is it not covering our members from taking buccal samples from any arrested person? And then with the compliance rate by the detectives in taking buccal samples, I also find it a bit difficult. The docket is being inspected. I think the ICDMS of the South African Police the integrated case docket management system states clearly there, I think, about the statements that are supposed to be taken on when a person is charged, what must be in the docket. I think we are missing something there. There are no maybe instructions that are given to the SAPS members to say, in this case, it's a must that you must have a copy of the buccal samples. Because as far as I know, in those Schedule 8 offenses or whatever cases, it's a must that buccal samples must be taken. And it is also a fact that there was once a shortage of these kits in the SAPS, and we did not acknowledge that. And also the hesitation of the members during the start of the COVID in 2020. I think it was very difficult for a member to take buccal samples. We must also admit that it was on our side. That's where we are having such a backlog, Chairperson. I think those are my inputs and questions to say a clarity on the criminal law that states that we or the police are covered to do their job. And then now we are struggling. We say now we want to pass the bill, whereas the section was there that covered, as the Civilian Secretariat stated, that the criminal law states clearly that buccal samples must be taken. So if I can get the clarity, why are we struggling that we must now amend and make some changes in the bill, whereas the law is there? Thank you very much.
Thank you, Honorable Shebeni. Honorable Marekwa.
Thank you, Chairperson. Let me maybe just show the face and close the video again.
No, Honorable Marekwa, that was not even showing your face. That was to show.
Morning.
Much better. Good morning.
Morning, and good morning, honorable members and delegation from the different sectors that came to present to us this morning: the police, the DNA board, and the secretariat office. Chairperson, mine will be brief. Let me just appreciate the report from the DNA that talks also. I think mine was on the reduction of the backlog, the numbers that they have given us there that led to the 65% where they are standing currently, which shows that from the total number of about 210,864, they managed to deal with 138,558 cases there. So I think that's a positive and a step in the right direction, as much as more still needs to be done in making sure there is real reduction in the backlog. But also having looked into the different, the other two presentations that also talk to the issue of the backlog. I think on the subs one that also talks to the intention to address the backlog. I've seen a number of slides, and then the slide that talks to having 34 hours of overtime, I think for me, Chairperson, might create a problem, I think, going forward for the future for the employees in the labs. It might create a problem because overtime creates a dependency where people would not want to take rest days, because having to look into the amount of money they get and the hours that they will be working. But this overtime causes problems in that at the end you end up having members who are overworked and also being at some stage overwhelmed by the load of work that they have to deal with. So I don't think that overtime would be an option going forward, but instead the police to look into having more people employed and make sure that the relevant and skilled analysts are employed so that to look into reducing issues of overtime and overworked staff. What is also important is that from the different slides, presentations, the labs that we are having currently, Western Cape and so on, Eastern Cape, KZN and Gauteng, where the slides are mentioning that the one that seems to be doing well is the Western Cape. I think more resources or more efforts needs to be put into ensuring that all the labs operate equally and are given the necessary attention, because it will mean that as much as Western Cape continues to be the best, now the load will be taken to Western Cape and we will continue experiencing the problems of backlogs and so on. I think it is important that talking to all the slides now, the regular maintenance of the machines, because there will be times where machines are giving a problem and the contractors not really assisting and doing what is needed. I think the regular maintenance of the machines is very important, making sure that they are able to deal with the capacity or the load that is put to that particular lab, all the labs, and making sure that as much as we attend to the machines, the buildings themselves are given the necessary attention, because issues of storage, of evidence and all that needs to be also given serious attention so that we have a better flow and processes of backlogs are not an issue going forward in the future. I think, Chairperson, it is important that we attend to those, but it's important that I know budgets will be there and many resources will be there, but human resource and it's very important that we have skilled people, because the age, people are aging, others are going on retirement, others look for better or greener pastures elsewhere or offers elsewhere. So we will continue losing members, but it is important that we are up to the task as the departments and make sure that we have people at hand who can deliver the service that is needed by the laboratories. Also, that decentralization, there's a slide that spoke to in the police that they are looking into decentralizing to one.
Recording in progress.
But I think it's important that the decentralization also continues. We cannot only have these 4 provinces, but because crime continues and there's no guarantee that it will reduce going forward, the level and the rate that we have these cases of rapes and other cases, robberies and stuff. I think we need to really, really invest in that and making sure that we continuously, we look into decentralizing and having more provinces having their own labs to avoid issues of traveling and long distance to a lab, maybe in Gauteng, whereas that budget could have been used for the maintenance and other things that will be needed by the labs. Thank you, Chairperson.
Thank you, Honorable Marekwa, for covering so many critical matters. And there's so many issues that you've raised and concerns which you've raised, which we all share. So thank you very much for those detailed questions and comments. I really appreciate it. Those have been concerns of the committee for a very long time. I now note it was first Honorable Groenewald. What happened to Groenewald? And then
I'm waiting, Chairperson. If I can speak, I can speak.
Yes, it's your opportunity.
Thank you. Thank you, Chair. Chair, firstly, I want to say the last presentation from General Rabi, I only received this morning, so I didn't have time to go through it. And I think there are some critical issues we will have to look into. So I just want to put that on record. Chairperson,
my apologies, sorry. My apologies, Dr. Groenewald. Honorable Groenewald, I put the General Rabi under tremendous pressure after Wednesday's meeting. So he basically only had yesterday to prepare his presentation. So I've been putting even the civilian secretariat under enormous pressure to respond to what we were discussing on Wednesday and what we had received from the public presentations on Wednesday. So I take full responsibility for the presentations only getting to you today. But I have been putting tremendous pressure on people. I apologize for that.
Yeah, no, it's no problem, Chairperson. Just what I want to say, I think there are really very important critical issues that we will have to study thoroughly, specifically when it comes to the bill. So it's no problem. But on my question actually, Chairperson, is as far as the DNA board is concerned, I want to ask that because the expungements on the arrested index, we talk about of 22,675, which is actually part of the 22,857 expunged samples. Now, my question is, if I understand it correctly, expungement means that it's lost. Maybe I understand it incorrectly. And my question is then, what happens with that cases? It is samples, it is important for a case, especially when we talk about arrested index. So that's my first question. My second question, Chairperson, is that it has been stated that the monthly influx samples being processed, the processed samples are 21,000. Now my question is, but what is the real influx number? The processed number is 21,000, but is the influx 30,000, 50,000? I see the capacity is 57,000. So I'd like to know what is the present influx. And taking that in consideration of what the presentation of General Rabia said, and he said that it was actually only for the priority Schedule 8 offences. So the other Schedule 8 offences is not, am I correctly, not included in that or not? So if I can get clarity on that. My last question, Chairperson, is it's stated by the DNA board that poor contract management led to the backlogs at the forensic science laboratories. Can they elaborate on me, what do they mean by poor contract management? That we can have a clear, can I say, information of what is the poor management. Thank you, Chair.
Thank you, Honourable Groenewald. Honourable Siabi.
Thank you, Chairperson, and greetings to DM and General Masemola, and join other colleagues in welcoming the three presentations. My question, Chair, my first one is in terms of Dr. Jacobs' presentation, maybe it's a follow-up to Honorable Shembe's question. Already in the Criminal Procedures Act, there's provision for taking buccal samples from anyone who's arrested. Why is it difficult to align that section of the Criminal Procedures Act to this bill? Because if you remember, COSATU in their presentation requested that they would be happy if everybody arrested and charged can be subjected to these buccal samples. Now, my question is, why is it difficult to align what is already contained in the Criminal Procedures Act, which is law, to align it to what we are discussing in this bill? Because If in this bill we only focus on Schedule 8, but in the Criminal Procedures Act is everybody, and then this bill is passed into law, then it would seem there's confusion, and it will send a message that we are confused. Maybe clarity on that one, and not only on issue of Schedule 8, but even on other areas. Why can't in this bill make reference to Criminal Procedures Act so that we don't have unnecessary confusion? The same with the use of minimum force. My question on that one would be, what do we mean by minimum force? Because in terms of the Criminal Procedures Act, it seems it is not clear. We must still apply before we can use that. The minister must still make a determination before we can do that. It seems not to be clear. What do we mean by minimum force? I think one of the presenters on Wednesday tried to tell us that in other countries, they put it clear that when we say minimum force, this is what we mean. And on the presentation of the DNA board, I think it really helps us a lot. And it addresses the concern that was raised by one of the presenters on Wednesday, who was worried about the capacity of SAPS in terms of addressing the backlog in the labs. I think that presentation tells us that SAPS has capacity. They just need to improve here and there. But in terms of capacity it is there. And then we must be put at ease, because once the bill is put into law, that will not be an issue of capacity, will not be a problem. In the presentation of SAPS, there's somewhere, although I agree with Honorable Grunewald that because it came late, we couldn't pay more attention to it. But there's somewhere in the presentation where it says that buccal samples were not taken routinely, although it is there in the Act. Now, my question would be why? What were the challenges that led to that, not implementing the Criminal Procedures Act in total? My last question, Chair, is out of the 1,200 police officers that will be recruited, as we were told, are there those that will be deployed to the labs? Are there those that will be deployed into the Division of Contract Management? Because the issue of contract management is coming time and again as an issue. Now, out of this 1,200, do you have people who will be deployed to the labs and those who will be deployed into contract management? Thank you, Chair.
Honorable Siabi? Honorable Siabi?
Chairperson?
Yes. Are you done now?
I'm done, Chairperson. Thank you.
Thank you very much. Honorable members, I know that a number of people on the platform have to meet with the minister at 11. So, Honorable DM, would you like to say something before you leave? Or have you left already? I think the DM has left already. General Masimola, could you manage the responses, please?
Thanks, Honorable Chairperson and members. General Mchinga and the Divisional Commissioner Detectives, Lieutenant General Sintumule will lead the response. Thanks, Generals. Can continue.
You may continue.
Thank you, Honorable Chair, honorable members, and senior management from the SAPS, and also from the CFPS. I will focus on the questions that were directly for the division, and also my colleagues will just fill up the gaps where I left. I've got General Mohale representing General Sintumole, and I've got also General Mangale and your General Mulawudzi and General Manamela. I'm going to talk on the issue of compliance rate of taking the Schedule 8 offences local samples. Remember, we had the issue of shortage of kits, so we were prioritizing only a Schedule 8 offences so that we must be able to comply. But as from the 1st of November, it was compulsory that we need to take the buccal samples as it is in the bill. So the current situation, that's why also you see there is an improvement in terms of performance. We are enforcing the members to take the buccal samples in all Schedule 8 cases. And also on the issue of Honorable Morekwa, the issue of overtime is not a long-term arrangement. It's a short-term arrangement for us to be able to manage to overcome the issue of backlog. So it's in our project plan. After the project has been finalized in August, we'll go back to normal because now there would be no backlog. So with the capacity that we are having of personnel, we are able to finish the backlog, and then from there will be no much hours for overtime. They will just be focused on the normal duty because all personnel have been appointed in their various areas, specifically with our analysts. That because that is where we had a huge shortage. It was analysts, so we've appointed people in those areas. So after the backlog, they will go back to normal, and also. The issue of going back to reverse with the backlog, I don't think we are going to have that problem now because all the contracts are in place, and also there's a regular maintenance of our systems and equipment. So consumables are also available. So there is no need for us to say we are going to regress. We are going forward because everything is in place. And also we have put a plan on the issue of contracts so that we mustn't have the problem of having our contracts expired and then we only start after the expiry date. So we've got a contract management committee that is looking at the issues of contracts before they expire. We apply, we send to supply chain. So when the date arrives, we are already ready. So there will be no hiccups as before. And then on the issue of not compliant, it's non-compliant on the taking of buccal samples. Yes, it's true. There was time where we did not have enough kits to take the buccal samples, as I said, but now everything is in place. There are buccal samples we are taking. And also, it's a reality that when COVID hits, everybody was scared. We didn't know, we were confused. So our members were also skeptical to take the buccal samples from the suspects. Now we are going to normal. Everything is going back to normal. People are starting to do their job.
My apologies for interrupting you, General. Mr. Amaru is allowed to leave. Dr. Jacobs is allowed to leave. As I said, they have a meeting with the minister. Advocate Bell will remain in the meeting to answer questions to the Civilian Secretariat. Mr. Sono and Dr. Ellis will respond to the questions directed to the DNA board. You may leave now. My apologies for interrupting you, General. You may continue.
Thank you so much, Honorable Chair. On the issue of forensic going to get people, remember, people who are being deployed at forensics, those are people who've got scarce skills who have been trained as analysts. So I don't think we'll be getting from the constables that are going out from the college, because when we advertise posts, we've got a specific requirement of the analysts. So constables that are in the college are for the general policing. So we all, when there's a gap of vacant posts, we do apply for advertisement of posts, because those people are the people who must be coming from the universities and the technicals, the technical environments. So from the college, I don't think we'll be getting, because those people do not have necessary skills to be placed in our forensics. So I think my colleagues will just fit in where I did not. And on the issue of labs, we appreciate the issue that we are starting to move very fast with the Eastern Cape lab. They are busy now putting furniture. I think they will be able to be done by next year with their date of finishing, which is February 2023. And also KZN, we are busy now starting with the site preparation. Very soon we'll be moving faster also to make sure that we do have a lab that is running in KZN. And also to have the labs in other provinces. It's something that is on the table, that we need to make sure that at least we must have labs that are going to assist with the first level of analysis, like we have the two in KZN. So this is where we are going, that we need to make sure that all provinces do have their labs, and ultimately at the end, then all provinces will be having fully fledged labs. But it won't be now. It's going to be a long-term process, because it's a very expensive exercise to establish a lab. So I would, through you, Chair, I will request General Mulaudzi and General Mohale to fit in where I did not cover. Thank you so much, Chair.
Thank you very much. Next.
Thank you very much, Honorable Chair. The members of the honorable members, I just want to respond to the question on the influx vis-a-vis the capacity that we have. My name is Jaram Lauzi, responsible for Forensic Science Laboratory. Honorable Chair, the influx at the present moment in Pretoria, we are receiving 8,000 cases per month. In the Western Cape, which actually all the provinces like KZN, Eastern Cape, and Northern Cape, they are sending their samples to Western Cape. We are receiving 13,000. Honorable Chair, out of that 13,000, it gives us 21,000 samples that are coming in every month that actually needs to be analyzed. But the capacity that we have of our system, we have, as it was presented, we have 4 lanes, and in these 4 lanes, we can process 57,600 samples. Of course, with the 20% where we do the planned maintenance, maintenance of the equipment, and the unplanned, so the number is a little bit less by maybe 7,000. But what I need to stress is that we do have a capacity, Honorable Chair, to analyze samples that are coming into the environment. We have a capacity of 30,000 new cases that can come to the environment for us to analyze. Thank you very much, Honorable Chair.
Thank you very much. Next.
Thank you, Honorable Chair, honorable members, senior members from SABS, colleagues. Honorable Chair, in terms of the, I think my DNC has covered very well. I'll just add in terms of compliance that was actually alluded to by Honorable Shembeni. In terms of compliance, Honorable Chair, we have measures linking up now from national, where we have kennels that will oversee or coordinate the taking of buccal samples from provinces, and to keep data in that regard to make sure that we comply 100% as per Act required, unlike before when we were just prioritizing from Schedule 8. Thank you very much, Honorable Chair.
Agreed. Next. General Masemola, who's next?
It's General Mangale, Honorable Chair. General Mangale.
Thank you. General Singer, please mute your mic. Next.
General Jinga, is it all the...
Honorable Chair, it's only us who are finished, Chair.
Thank you very much. Do we still have speakers from the DNA board or the Civilian Secretariat?
Chair, it's Advocate Bell from the Civilian Secretariat. If I may give our inputs now with regards to the bill, the questions that were raised on that.
Yes, you may continue.
Thank you, Chair. Thank you, Chair. Chair, I'm going to deal with Honourable Member Shabeni's question about the Section 36D1V, any arrested person refusing. So yes, this covers the concern that was raised about all the other schedules that there were, where there was a proposal that we should include all the other schedules. So this covers those people who are arrested and fall under any other schedule. So that is covered. It's already established in the Criminal Procedure Act. Then with regards to the other question that was asked, also in connection with the same provision, the taking of buccal samples under the Criminal Procedure Act. Yes, I think, Chair, what we need to mention here is that this particular bill deals specifically with transitional arrangements. Those transitional arrangements, the time frame lapsed. So this is what we are dealing with now. And it covers the Schedule 8 convicted offenders. Yeah, so it deals with them. And as was also mentioned, Schedule 8 does cover quite a number of the other schedules that were mentioned. So we also need to say that if now we're going to include all the others which are already included in the Act, we have to take into consideration the cost, the numbers, and the relevance of taking those buccal samples from other convicted offenders who fall out of the Schedule 8 prescription. So yeah, so we and also the administrative burden that this will now cost of taking every single person that's in prison, taking their buccal samples. So we, in the main, are dealing with the Schedule 8 convicted offenders, that the people that are already there, but those that are being arrested currently and before this, when the Act came into place, those were already dealt with in other provisions. So we are not overhauling the whole Act. We are only looking at the provisional measures that where the time frame had lapsed. Then with regards to the question on the minimal force that the bill envisages, is that reasonable and necessary force will be used, which is minimal, when the convicted offender refuses to have his buccal sample taken. And as stated previously, this provision is already established in law, for example, in the SAPS Act, Section 13(3)(b), in the Correctional Services Act, Section 1332, and also the bill provides for the national instructions to dictate how this minimum force must be administered. I hope this covers the questions that were asked. Thank you, Chair.
Thank you very much, Advocate Bell. The DNA board.
Chairperson.
Thank you very much. You may continue.
This is Raymond again. I had a challenge with my gadget this side. I was off for a very long time, so I'm not so sure as to whether there was many questions before when I was gone. But when I come back, I heard the
Mr. Sono, my apologies for interrupting you. Please respond to what you have heard. And if there are questions which you haven't heard, we'll send those questions and comments to you in writing, and you can respond in writing. So just respond to the sections where you have had connectivity.
Thank you very much.
If the members' questions are not responded to, we'll inform you and you can then respond in writing. Thank you.
Thank you very much, Chairperson. I hear the question that says, what do we mean by poor management of contracts or poor contract management? I personally would like to withdraw this statement, because initially I heard someone saying in this platform that we understand the frustrations of our politicians and everybody who is working on these challenges that we had. Initially, when we began with the work as a board, we believed that the contracts or else the applications are made when the contracts are expired, kind of. And we also believed that the times for making contracts are very, very, very short, small. We never had governing regulations about all this logistics part of it. However, as we continue with work, we came to clarity after few and several meetings and engagements. Like I was saying, we as a board at the present believes that the challenges we had emanated from the Scopa DFA saga that led to CJS budget affected, which was supposed to be given to the lab, and through you, Chair, and the PCOP again, Minister and DM, we managed to find ourselves being clear about everything, and we reached up to where we are. That the challenges that we had, it was lack of funds, which was like 250 million that was cut, which the lab needed desperately. Therefore, I withdraw that statement, because as we began to interact with the logistics and the supply chain, we realized that they are putting more efforts. They are coming in our meetings with them. Every time they are coming up with a new report that shows progress on their side. And we learned that that relief baseline budget helps them to do the work. Therefore, I think it was also brutal on the side of the division and the side of the the logistics, to say there had been contract management, poor contract management. I don't have evidence with that writing personally. Therefore, as for me, from my side, I withdraw that statement. The reason should remain in the presence that we needed funds to be operational, seeing that the problem of reagents, consumables, and maintenance of machinery, and other needs that I might not be mentioning from my side. Thank you, Chair.
Thank you very much, Mr. Sono. General Rita and General Vuma, would you like to respond?
Honorable Chair, a point of order. Sorry.
Yes. Dr. Groenewald?
Chair, unfortunately, on this point, I must come in now.
Yes,
This
you
is
may.
this is totally unacceptable. How can a presentation being presented to this committee, and what is actually just has been said is that it was misinformation there? It's totally unacceptable. I mean, what were the original or initial reasons to say that the poor contract management was the reason for the backlog? To hear this explanation is not acceptable to this committee. It means that the presentation was not checked, the facts were not checked, and in essence, it comes down to the presentation then lied to the committee. And I expect that this must be taken further. It is totally unacceptable for me to receive a presentation, and if you ask a question on a critical issue and a critical statement, that you must hear, now I withdraw it. It's not acceptable, Chairperson, and I expect steps as far as that is concerned. Thank you.
Thank you, Dr. Groenewald. That is why I'm asking General Reed and General Vuma to assist me from their side or accordingly. General Reed? General Reed, I can't hear you.
Good morning, Chair. Can you hear me now?
Yes, General Reed.
Thank you very much. Good morning, Chair, to you, and good morning, Members of Parliament, Deputy National Commissioners, and my colleagues. Chair, as the board was indicating, I will not say there was no contract problems in the South African Police Force, specific reference to forensic laboratoriums, as he indicated in his presentation. Chair, I can just say that, yes, there was issues about, if you remember, when the National Commissioner came in, he had actually conflict together with another supplier, which was under operating under FDA, which was having huge numbers of contracts in the space of forensic environment. Now, during that particular time, there was also some certain questions raised during SCOPA session, and which was also problematic in the sense that these particular contracts were some sort of evergreen, meaning that this particular company was giving services to forensic services without actually adhering to Section 217 of the public fund of the Constitution in terms of making sure that everybody is actually considered, and actually it's a transparent process where other suppliers can also have a chance to participate in giving proper services to forensic service. Now, eventually, in terms of contract management, you have to dig deep inside as to find out whether other suppliers can also be approached, and actually giving proper market research to find out whether other suppliers can also contribute towards giving service to the South African Police Service with reference to forensic services. Now, Chairperson, we succeeded in that particular approach, despite the fact that also funds were not made available, because Treasury also had a problem on that particular time to issue funds, because they were of the opinion that we actually don't manage the funds according to the state prescripts, as well in terms of Section 217 of the Constitution. Now, the Chairperson, as a President of the Board, was saying we had numerous problems. Contracts were not in place because of these particular issues, and as I was also presenting before, it doesn't mean that if money is being given, then you immediately get contracts. It's a process in terms of the supply chain management procedures and prescripts to put a contract in place. But I can just say, Chairperson, and I'm feeling honored also by the fact that the board is very much happy by the fact that contracts are in place. I'm not saying that going further that we will not have problems, but problems will always be there. But we've actually minimized certain problems, and that's why you can see the results in forensic services laboratories, together with other challenges that was also resolved. Chairperson, I can say really at the stage, in terms of contract management, we're doing our utmost best. The question also relating to whether the recruitment process is going to be catering for contract management, I can just say at the stage, no, Chairperson, because at the stage, the focus point of the organization is the operational services, meaning that the guys who are actually wearing more the uniform and the detective services. There's no provision being made at this stage for the other occupational classification, but I believe going forward in the next recruitment processes, we will actually be taking care in terms of contract management. Thank you very much, Chair.
Thank you very much, General Reid. General Nsinga.
No, I'm covered, Chairperson. I think General Reid has rounded off very well. Thanks, Chair.
Thank you very much, General Buma.
Thank you very much, Honorable Chairperson. General Reid has rounded off, but just to also explain that it is true that we are not recruiting directly to the organization in regards to expertise that we require from forensic science laboratories. However, with the directives from our ministers in this new recruitment drive that we are currently busy with, we make provision for us to be able to advertise 200 posts of the trainees that has got BSc as a qualification. The objective of doing that is for us to have a pool sufficient in the within the organization that shall have been employed as constables, working in different police stations, acquiring sufficient experience and exposure in the organization, so that when a need arises for us to capacitate the forensic science laboratories, we are not going to be looking from outside. We will be having people who understand the organization, who will be in a position to be recruited in that particular space. Thank you very much, Chairperson.
Thank you very much for that contribution, General Buma. Honorable members, Dr. Groenewald has made a very valid point. I do wish to say that I insisted that the DNA board be present. Now, I'm going to write a letter to the minister and the chairperson of the DNA board about this. On Wednesday, the DNA board was not available because they said I had given them insufficient notice. Again, after the committee requested that the DNA board be here today, I informed them that they should be here today. They once more told me that I had given them insufficient notice, to the extent that I was on the brink of summoning them to the committee. Now, the DNA board cannot treat the committee in this fashion. It is disrespectful and it's undermining the work of the committee and the constitutional responsibility and powers of the committee. Honorable Groenewald, I've had serious concerns and real problematic interactions with the board. And allow me to also express my dismay. It has not been a pleasant experience to interact with the board. They've been reluctant to cooperate. They've been reluctant to send me presentations. And this essentially is a bill which impacts on the DNA board in particular. And I think that they should have been ahead of the process. They should have not been dragged to this committee, and they should have in fact requested to see the committee. They knew that we were busy with this a set of amendment legislation. So I'm going to be speaking to the chair and writing a letter to the chair and writing a letter to the minister. Nicolette and Babalwa. Nicolette, please prepare the letters to the minister and the letters to the chairperson. I had to contact the minister and the deputy minister on Wednesday after the chairperson just refused to appear at the committee. So yes, I understood that she had some court matters, court-related matter, but she was even reluctant to send a replacement. Now, I promise you, I had reached the end of my tether, and I was extremely frustrated with the board. So let that be a lesson. If you refuse to appear or send a replacement, you will be summoned to this committee. And as Groenewald said, if you do not give us accurate information, you are misleading the committee, and it's an offense. And those offenses will not be swept under the carpet. How do we do our oversight work if we are not given correct information? It's misleading the committee, and that will be put to you in writing. I'm sorry to end this meeting in this fashion, but I just want to indicate to members that by yesterday, I was on the verge of postponing, first cancelling, and then postponing this meeting. We would have had to postpone our meeting because of the board's preference for the date and schedule of a meeting. So their meetings and their lack of planning and preparation was impacting on our work. So yes, I do know I'm not going to take any hands. You will have an opportunity, Mr. Charles, whoever you are, to respond to me in writing. I'm closing the meeting. Mr. Michael, Charles, whoever you are, I have not asked for hands. So you can put down your hand. Honorable members, you'll be informed of the further processes of the processing of the bill. The further processing of the bill will also be made public. And as we move along, we'll keep you all abreast of developments and responses. So as we're moving along, if you've made comments, all those comments will be factored into the work that we are doing. We are taking copious notes. And our researcher and content advisor, she's performing a due function, has two jobs, but she is doing a sterling job on managing the content and information and doing the research for this piece of legislation we are taking through Parliament. This is a very important piece of legislation, and we cannot get it wrong. We have only one opportunity to get it right, and we will get it right. Honorable members, with that concluding remarks, I'll keep you informed. All those members, thank you very much for your comments. Honorable Marekwa, Shembeni, the WIP, Groenewald, I appreciate those I haven't mentioned. We have considered what you have said, and I'm following what you have said and the responses you get with a keen interest, and Nicolette is doing the same. With that, honorable members, Honorable Whip, thank you very much to General Masimola and the senior management of SAPS, to the members of the DNA board. I know you were thrown in at the deep end, Mr. Sono. I'm not pinpointing you and speaking to you. The interaction I had was with the chairperson of the board. So, Mr. Sono, please don't think that these comments were directed at you. I do recognize the challenges which were presented to you, and you will not be thrown under the bus, because actually you have not been responsible for what happened today. You will not let off the hook, but you will not be thrown under the bus. Through the Civilian Secretariat, Advocate Bell, and to the team, thank you very much. We'll be working together in a very tight fashion to ensure that the comments are taken on board and that our work is done very smoothly. With those comments, I now declare the meeting closed, and you'll be informed and you'll receive a notice for the next meeting. Thank you very much. Thank you, members. The meeting is over.
Thank you, Chair.
Thank you,
Chair. Bye.
Thank you. Bye.
Recording